Welcome to Shorthand study classes. Get ready for free and progressive shorthand dictation. Start. Banks and financial institutions lend public money to assist entrepreneurs in their business start. Thus, on one hand, there is the interest of public whose funds are utilized, while on the other hand are the business establishments which need funds for their business start. Banks and financial institutions, in a sense, are intermediaries in the process start. Litigation instituted by banks and financial institutions became colored by gross delays in the civil proceedings, as a result of which defaulters were at a premium start. Borrowers who maintained financial discipline were the ones at a disadvantageous start. The borrowing process was being misused and a large amount of public funds were stuck in litigation start. In order to expedite the recovery of dues, the RDB Act was enacted by Parliament on 27/8/1993 and brought into force with effect from 24/6/1993 start. The RDB Act provided for the establishment of a tribunal for expeditious adjudication and recovery of debts due to banks and financial institutions and for all matters connected therewith start. The RDB Act is comprehensive in character in terms of providing the methodology towards the said objective start. Para. Banks and financial institutions at present experience considerable difficulties in recovering loans and enforcement of securities charged with them start. The existing procedure for recovery of debts due to the banks and financial institutions has blocked a significant portion of their funds in unproductive assets, the value of which deteriorates with the passage of time start. The Committee on the Financial System, headed by Shri M. Narasimha, has considered the setting up of the special tribunals with special powers for adjudication of such matters and speedy recovery as critical to the successful implementation of the financial sector reforms start. An urgent need was therefore felt to work out a suitable mechanism through which the dues to the banks and financial institutions could be realized without delay start. In 1981, a committee under the chairmanship of Shri Tiwari had examined the legal and other difficulties faced by banks and financial institutions and suggested remedial measures including changes in law start. The Tiwari Committee had also suggested setting up of special tribunals for a recovery of dues of the banks and financial institutions by a summary procedure style. The setting up of special tribunals will not only fulfill a long felt need but also will be an important step in the implementation of the report of Narsimha Committee staff. Whereas on 30/9/1990, more than 15 lakhs of cases filed by the public sector banks and about 304 cases filed by the financial institutions were pending in various courts. Recovery of debts involved more than rupees 5,622 crores in dues of public sector banks and about rupees 391 crores of dues of the financial institutions star. The locking up of huge such amount of public money in litigation prevents proper utilization and recycling of the funds for the development of the country star. It is pertinent to note that a challenge was laid to the RDB Act as it originally did not contain any provisions allowing a defendant in an application filed by a bank to claim any set of or counterclaim against them star. This issue received consideration in Union of India and another versus Delhi High Court Bar Association and others star. By the time the judgment was made, the RDB Act was suitably amended by Act 1 of 2000 to include such provisions and consequently the same was upheld star. The statutory framework in a tribunal shall exercise on and from the appointed day the jurisdiction, powers, and authority to entertain and decide applications from the banks and financial institutions for recovery of debts due to such banks and financial institutions star. A tribunal shall exercise on and from the date to be appointed by the central government the jurisdiction, powers, and authority to entertain and decide applications star. The tribunal shall have circuit sittings in all district headquarters star. An appellate tribunal shall exercise on and from the appointed day the jurisdiction, powers, and authority to entertain appeals against any order made or deemed to have been made by a tribunal under this act star. In this act, unless the context otherwise requires debt means any liability inclusive of interest which is claimed as due from any person by a bank or a financial institution or by a consortium of banks or financial institutions during the course of any business activity undertaken by the bank or the financial institution or the consortium under any law for the time being in force, in cash, or otherwise whether secured or unsecured or assigned or whether payable under a decree or order of any civil court or any arbitration award or otherwise or under a mortgage and subsisting on and legally recoverable on the date of application 1 and includes any liability towards debt securities which remains unpaid in full or part after notice of 90 days served upon the borrower by the debenture trustee or any other authority in whose favor security interest is created for the benefit of holders of debt securities stock on and from the appointed day. No court or order or other authority shall or be entitled to exercise any jurisdiction, powers, or authority except the Supreme Court and a High Court exercising jurisdiction under Articles 226 and 227 of the Constitution in relation to the matters specified in Section 17 Strap.